Richards.
Thank you, Your Honor. I first want to make sure that the court received a letter that Ms. Danielson wrote. We did provide to the probation department on 2 occasions. The letter is dated November 8th of 2022.
Just had it. Oh, here it is. I just had it in my hands. Yeah, November 8th. I had that.
All right, and Your Honor, Ms. Daniels does want to address the court this afternoon.
All right. Did you wish to say anything
I
before or
do.
after her?
I'll wait.
Okay. Ms. Danielson, we're going to get a recording device near you. Hold on. All right. If you could please stand up and state your name for the record, please.
Sandra Danielson. Mr. Zanon, when you and your friends planned out the attack on my son, Trent McWilliams, was wearing steel-toe boots part of the plan? Were you concerned about the fact that steel-toe boots are considered a dangerous weapon or the damage they could cause? You kicked him in the head and body and left holes in the top of his head. Trenton is mentally younger than you and all of the other 9 people that were there that night. Trenton has had to be weary of anywhere he goes for several years now because of your friends. Now he has been chased through town and threatened by you and your co-defendants, harassed online, made fun of when he would go on live. A few times when he was harassed online and retaliated, your friends recorded his retaliation. Now you all throw this out, but not the things you said to him. The things that got him to the rants and comments he made. You and your co-defendants know exactly how to get him to that point and then sit back and play the victim. I experienced some of what he felt recently when I ran into a friend of mine. She introduced me to her friend. Giving her my name, said, "This is the girl that son was beaten up last spring." I immediately felt like the whole room was looking at me. I didn't know who anyone in there was. I don't know you. I don't know your family. And there's 9 other people that were there that night. They all have family. Anywhere my son goes, he feels what I felt that night, and I wasn't the one assaulted. He is scared. That needs to stop. He should be allowed to feel comfortable in his own town, not like a target. Someone swerved at him the other night in their vehicle. He believes he knows who it was. It was not you, but it was a different defendant. And I can only imagine how he felt when he was laying on the ground, being kicked and punched and stomped on by 6 men wearing masks. I hope at some point you picture yourself laying on the ground, having 6 people stand above you, kicking, stomping, punching. I can't imagine how he felt just from that, not let alone the pain. Some of your co-defendants stated you and Mr. Loomis were still beating on him when they returned to the truck. Less than a week after being arrested for this assault, he broke bond by drinking and driving recklessly, reported by several people. You broke bond a second time after that. You faced some consequences. You were tethered, you sat in jail, but I hope you do spent some jail time for the assault you put on my son. In their police report and interviews, some of your co-defendants stated that after the assault, you all made a story for yourselves. Your story included that my son had a gun, and that's why you all had to go there. That's kind of the dumbest thing I've ever heard. Because if someone had a gun, I certainly wouldn't go to an area I drew them out to and try to beat them up when they have supposedly a gun. And you claimed that that was to go there to protect Mr. Thompson. When Trenton's biological mother passed away, you and your friends had no problem saying rude, inappropriate things to him. You all teased and harassed him. And when he retaliated with words back towards Peyton Thompson's mom, that was another excuse to do this to him. The fact is, there's no excuse to do this to anyone. Your actions caused serious injury and trauma to my son. He now has PTSD, anxiety, and has been depressed since this assault. He already had cognitive and memory problems. Those have become worse. It's like I'm starting all over, trying to get him just to do the basic things in life. Your actions could have killed him. Rather than taking responsibility for your actions, you want to make excuses. You try to justify what you did, blame the victim, and minimize your involvement. I hope at some point you do picture yourself on the ground with these people above you so that you can have some kind of idea how he must have felt. I can't even imagine how he must have felt, how terrifying that was. And then he was left there to make his way almost 3 miles for help in that sort of condition, without one of you calling for help, making it stop. Not one of you went back to make sure he made it to safety. It was like 28 degrees outside. If he would have dropped from a brain bleed or anything else caused to him, he would have died. That's all I have, Your Honor. Thank you.
Thank you, Ms. Danielson. Ms. Richards.
Yes, thank you, Your Honor. Your Honor, I have reviewed the pre-sentence report and recommendations of the probation department. The court will recall, as has been alluded to by Ms. Danielson today, that Mr. Zanon did have 2 bond violations resulting in his bond being temporarily revoked. So he comes to sentencing today having 28 days of credit toward whatever jail time he receives. I concur with Ms. Miller's summary of the incident, Your Honor, specifically that Mr. Zanon is reported to be the one who inflicted the most damage to Mr. McWilliams. It was believed by some that he may have been wearing steel-toed boots, as he usually did. And from a proof standpoint, however, the prosecution could not prove that beyond a reasonable doubt. Had we been able to do so, Mr. Zanon would likely have been charged with felonious assault. As the court knows, Mr. McWilliams was seriously injured. He suffered lacerations on his nose and eyelid that required sutures. He treated for a concussion, which included several weeks of physical therapy. He had 2 broken teeth, which may require additional treatment in the future. And in addition to the physical injuries, he also suffered mentally and emotionally as a result of this incident. And from what I understand from Ms. Danielson, continues to And as I've stated at prior sentencing hearings, Your Honor, emotions in this case have run high. There is reportedly some history between Mr. McWilliams and at least one of the co-defendants involved in this. But that history does not in any way justify or excuse this conduct, legally or otherwise. The question for the court today is, what is the appropriate sentence for Mr. Zanon? One that seeks to sufficiently punish him, deter others from engaging in this type of crime, and make Mr. McWilliams whole to the extent that that is even possible. And as we all know, he will continue to have physical scars as well as non-physical reminders of this probably for the rest of his life. I think the sentence recommendations here are certainly in line with the co-defendants who were already sentenced in this court. Does Mr. Zanon deserve a harsher sentence for being the one who inflicted the most damage? I would leave that up to the court's discretion. I am asking the court to enter an order for restitution in the same amount that has been ordered in the co-defendants as well as the co-respondents case, which is $3,113, and that has been ordered joint and several with the others. And lastly, Your Honor, we are asking that the court follow Ms. Miller's recommendation for no early release from probation. We simply don't believe that early release is appropriate in this particular case. Thank you.
Thank you. Mr. Zanon, anything you'd like to say?
I'd like to say to Mr. McWilliams that I hope he physically and mentally gets better as soon as possible. And I'm sorry.
All right, thank you, Mr. Zanon. Well, you've sat through here patiently listening to all of these proceedings as they have gone along. I think as time has gone on, hopefully you've gotten an idea of really the magnitude and breadth of the impact, negative impact of the behavior that night in question. And your attorney very eloquently put some of the maybe explanation for why you behaved in the heinous way that you did on the night in question, and that is the pack mentality, essentially. But you have to separate yourself from that, as he also said, because you're an adult, and not just because you're an adult, because you're a human being, and your moral compass should tell you that that's not appropriate, and to be strong enough to stand up to any friends or anybody else in the world that is acting in an inappropriate manner. And when I hear that you were the ringleader as far as the infliction of the physical damages, I have great concern, Mr. Zanon. I really hope that this was an isolated incident and something that was a result of your immaturity and something that's going to make a lifelong impact on you, because certainly Mr. McWilliams is going to be dealing with this on a lifelong level, on some level, due to his frailties and issues that he came in with. This is more severe for him. It's going to be longer lasting and have probably a wider impact than on maybe somebody that doesn't have quite as many issues as he has. However, what you should be understanding is, on the flip side of that coin, you should bear the thoughts for the rest of your life of how easily you can go astray and cause this kind of physiological and mental health damage to somebody else, and restrain yourself, because that is a badge that you're going to have to wear for the rest of your life, and then really a penance that you'll have to pay, because that's something that's just never going to go away from your mind, nor should it, that somebody suffered and will continue to suffer at your hands and your lack of judgment for the rest of their life. So you spend the rest of your life trying to pay it forward, and you do whatever you can to help Mr. McWilliams along. You tell your friends to stop behaving that way. you don't behave that way. You stand up for right, because right will always triumph over might, in my mind. You just stand up for right, day in, day out. That's your task. In the meantime, hopefully you'll find a way to make it up to Mr. McWilliams on some level and ensure that your behavior is straight and conscientious and above board for all the rest of your days. I think the recommendations here are appropriate. I am going to follow them. The objectives of sentencing are, one, to punish the individual first and foremost for their wrong deeds. The second goal of sentencing is to protect society from individuals such as Mr. Zanon who have engaged in this type of behavior. The third goal of sentencing is to deter others from behaving this way because they've seen the consequences of what happens to people that act in this manner. And lastly, to try to rehabilitate the individual who has done wrong. And so the goals of sentencing are for balance here and what is right and what is wrong. It's not always easy to strike a balance. We have very severe injuries, very far ramifications with what happened to Mr. McWilliams. On the other hand, Mr. Zanon does not have any prior criminal history. He was 18 years old when this occurred and really still youthful. And so for those reasons, I do believe that individuals that have no prior criminal history here in the district court, especially where this case was brought by the prosecutor, it's the prosecuting attorney's function under the way that our laws are set up to determine what charges are appropriate. Ms. Richards had determined, as you heard her say here today, that she felt that she would not be able to prove steel-toed boots, which would elevate it in her mind to an aggravated felonious assault. Rather, charges were brought here. Mr. Zanon, I do believe, should have an opportunity to try and earn the right to have this not go on his permanent record. In respect to both counts 1 and count 2, I am prepared to impose sentence under the delay of sentence standard statute, which is 771.1. I'm going to impose a 12-month term of probation, and I believe that the probationary term is important and necessary for the period of oversight to demonstrate that he will be able to comport his behavior, follow the terms of probation, and earn the delay of sentence. If you do not, if you cannot comply with probation, for example, if you decide to go down to Niagara again and imbibe in some more alcohol, guess what? Your delay of sentences are going to be gone, and these can appear on your permanent record. So what happens basically is going to be up to you in the next year, Mr. Zanon. No early discharge from your 12-month term of probation. There is a $400 oversight fee for probation. Fines and costs on count 1, $640. Fines and costs on count 2, $440. $300 attorney fee assessment. I am going to set restitution at $3,113, joint and severable with co-defendants. Are you working, Mr. Zanon?
Yes, Your Honor.
And are you working full-time?
Yes, Your Honor.
And how much are you earning a week gross wages?
About 550.
And what kind of debt do you have each month?
About $800.
So you're making about 2,400, give or take, and you have about 800 in debt?
Yes, Your Honor.
All right, I'm going to order then restitution to be paid along with fines and costs. I believe I set the co-defendant at 300.
Mr. Zanon was prepared to pay $300 per month.
All right. And when is that going to start? Can you start today?
I don't have the money. Well, if I can get to the bank in time, otherwise tomorrow.
January 15th and each 15th of the month thereafter until further order of the court. $50 for the justice system assessment fee and $75 for the crime fund fee. That's a total of $1,905 plus the restitution.
Now, when those are paid, are those being paid in one monthly installment of 300, then goes towards each of those balances? The
I
rest of the
believe,
payment?
that's what I said on the co-defendant as well, Ms. Richards, you recall?
I don't recall, Your Honor.
I don't think you'd be in a position to pay 300 to each month, 300 towards that total of a little over 5,000.
All right, I'm gonna set that at 300 total.
Thank you.
And in regard to the matter, then I'm going to impose 90 days in jail, 28 now, credit for 28 already served. 62 will be suspended for successful completion of probation. In addition to the general terms of your probation, the following are specific. You must attend and complete an anger management class. You must absolutely abstain from the possession or consumption of alcoholic liquor in any form whatsoever. You may not use, possess, or consume any non-prescribed controlled substances or prescription medicines that aren't prescribed to you. You must avoid all people that use, sell, or possess those items. Recreational marijuana use and possession are prohibited. You are subject to random PBTs and drug screens. You may not engage in any harassing, intimidating, assaultive, or threatening behavior towards any person. You may not have any contact with Trenton McWilliams. You are not to possess or use any social media, including but not limited to Snapchat, Facebook, Instagram, etc. You are not to be on the property of W5678 Swede Lane in Norway. Do you understand the conditions of your probation then, Mr. Zanon?
Yes, I do, Your Honor.
All right then, Ms. Richards, anything else on this matter?
I don't believe so, Your Honor. Thank you.
Mr. Percola?
Just one matter, Your Honor. If it's the court's intention to give Mr. Zanon an opportunity to have this not entered onto his record, I believe that HIDA is the only way to do that. I'm not sure that the delayed sentence statute under 771.1 accomplishes that same feat.
Well, I guess I'm intending that if he completes his delay of sentence status, it would not be accessible to the public. It would remain decipherable to the law enforcement system.
But I think under 771.1, what would actually happen is that there would be a finding of guilt, there would be a conviction, and that conviction would remain on his record going forward, even if he successfully completed all of the terms and conditions that have been laid out here for him. And that's my concern. I know the difference between that and HIDA is simply, as we indicated at the plea hearing, we'd asked the court to withhold a finding of guilt under the terms of the HIDA statute so that we'd have an opportunity to argue it today. It's that withholding of the finding of guilt that kind of keeps the conviction in the air and allows for a dismissal at the end of a probationary term should he successfully complete it. I just, in my looking at this closely recently in preparation for today, I don't feel that they're equivalent in that way. And so I bring it up because if that is the court's intention, I think HIDA is the only way to achieve that.
Ms. Richards?
Your Honor, the end result is the same, I guess, in my opinion, and I don't think Mr. Zanon should be treated differently than any of the co-defendants that have already been sentenced.
Well, I'll tell you what, Mr. Perkel, I'd be willing to set this over for another day if you want to continue argument and present some information in writing on that, but at this point, I'm not inclined to grant that. I don't have any. I mean, I guess I'd want to look at the issue a little bit more closely.
And I'd be happy to, Your Honor. Would the court be able to impose the sentence as indicated so far, and then pending the result of that issue, just add that term, or?
Amended judgment.
Amend the judgment, it would have to be, I believe, as well. So I can do that. We'll set it over, give Ms. Richards a chance to respond in writing. How long before you can present something of a legal nature, brief-wise?
The end of next week.
All right, I'll give you 14 days. Do you want 14 to respond, Ms. Richards?
Yes, Your Honor.
All right, let's look at setting a continued sentencing hearing for,
February 23rd?
yes, is that Mr. Perkel's regular day?
Yes.
All right. 9 a.m.
Yes.
All right, thank you very much, Your Honor.
All right, so in regard to the matter then as it sits, Mr. Zanon, do you understand the terms of your probation?
Yes, Your Honor.
And did you understand the appellate court advisal I gave earlier?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Judge, what was the date again?
Twen-
2/20.
3 at 9 a.m.
Thank you.
With the probation department not being available just now, I'm going to direct Mr. Zanon to contact them tomorrow and give a card to him so he can contact the probation department. Then is there somewhere that he can turn in his tether then, in terms of just go to the sheriff's department and do that rather than through the probation office now?
Yeah, good question. I don't know if the sheriff's department will take it in.
Last week when I spoke to Sergeant Wiley, he told me when I would get off that, or when I was done with court today, he said that just to go down there and someone would take it off for me.
All right, so you can have that taken off down there today. I don't know if we should put that on the judgment of sentence.
I think it would happen by way of operation, since bond ceases once the sentence is passed here.
Here, I'll just write it on there.
And are we adjourning the sentencing, or is this gonna be a motion? Like sentencing?
It's a continued sentencing hearing. All right, so you call probation first thing tomorrow morning. They're open at 8 o'clock. Any questions?
No, Your Honor.
All right, thank you.